guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. So this morning in New Mexico, the Supreme Court justices met and they heard the oral arguments in the case of Alexee Trevizo. Obviously, this is regarding the HIPAA violations as far as the video is concerned that the district court judge, tossed out of the case. And this is the decision that the state wants, obviously, to go in its favor, and I know I do. But if you are not familiar with this case, I just want to back up just a little here. Please do check out my playlist. I have extensive coverage of Alexee Trevizo. She is a 19-year-old, well, she's not 19 anymore, who went to the hospital complaining of back pain, and instead she gave birth to a baby in the hospital bathroom and decided to throw it in the trash and hide it in the trash can. Later, the cleaning woman located the deceased baby in the trash, and law enforcement was called. And there's arguments about the body cams as far as that's concerned. Again, if you haven't seen them and you would like to go through them, I will link to the playlist, and you guys can definitely go through that. It's pretty, like I said, it's pretty extensive. But without any further delay, I know if you guys hadn't seen the hearing today or heard about it, we are going to jump right into that.
Good morning. You may be seated. Thank you. Good morning. We're on the record of S1SC 40487, interlocutory appeal, State versus Trevizo. We have on opening 20 minutes. You may enter your appearance and proceed.
Thank you, Your Honor. Michael Thomas, NMDOJ, Raul Torres, Attorney General for the state.
Morning. You may proceed.
Thank you. May it please the court, counsel, and attendees. This case, still at the pre-trial stage, involves two narrow legal issues, specifically whether the district court's decision to suppress evidence was factually supported and legally sound. The district court erroneously concluded that there were violations of Miranda and of the position-patient privilege. Many of the court's key findings are either not supported by substantial evidence, or even if they are, do not support any assertedly related legal conclusion, revealing that the district court was mistaken about the applicable law. The interaction of the doctor, other medical staff, and defendant, as well as the police, are captured on the lapel video in the record as Defense Exhibit H from the suppression hearing. A careful review of the video is critical to a proper understanding of the issues, as it undercuts a myriad of defense assertions and glaringly fails to support and outright contradicts the district court's findings, as well as various characterizations in the ruling.
Counsel, I'm going to interrupt you in two things. First, you need to slow way down. Second, I'd like you to address pretty much right out of the gate State versus Ibarra.
State versus
Ibarra. It seems to be a case that answers this question a little bit.
And I'm not immediately familiar with that
case,
Your Honor. I'm sorry. I'm trying to do my best to answer your question.
Okay, so I'll try and tee it up a little bit for you because I don't want to completely catch you off guard. So this is a 1990 Supreme Court case. And in that case, it's discussing the term interrogation for purposes of Miranda, which seems to be an issue here. And it says that under Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit incriminating response from the suspect. So that's that concept. Does that help?
Yes, and,
Okay,
Your Honor,
good,
and I do remember Ibarra. Sorry, I
Okay,
didn't
no,
understand, but then I recognized it was Ibarra, which is cited in the brief. So I'm
Yes,
sorry.
okay, no, that's okay. So I would like you to address that statement that comes from Rhode Island versus Innis, but was adopted by the New Mexico Supreme Court.
Yes, thank you. And I do recall Ibarra in the briefs. Your Honor is right that interrogation under Innis can be express questioning, or it can be, as Rhode Island Innis talks about, actions or statements by the police that are, as they say, that the police knew were reasonably likely to elicit an incriminating response. The reason why the state believes there's no interrogation here, Your Honor, is when you look at the video, just so we're all starting from a baseline, the police do not ask her any questions at all. The police do at one point ask the mother, does she have a driver's license? They hand that over. Of course, they're going to run everyone for warrants, like showing up at a car accident scene. But as I cited in the briefs, you know, we all are familiar with cases that say they're asking for a driver's license name, and that's procedural. That doesn't count as interrogation. So then the question would be, did the police say anything that would be, as Innis says, reasonably likely to elicit?
It was not saying it can be actions as well. And that's what I want to focus on is actions, because I get that the police didn't say anything, they didn't ask questions. But here my concern is that if we only review the video and that's out of context to what the police have been told prior to going into the room. There's been a report. They've heard from the nurse, probably things maybe the nurse shouldn't have told them. And then they're invited to go in. And so there's action as a result of that that's different than like they just pop their head in, or if the report had just been made without healthcare folks tying the report to this young lady. That might be different if they were just going room to room saying we'd like everybody's name and information. But here they have this body of knowledge before they walk in the room. And that's what troubles me in this case.
Yes, and I'll do my best to answer. And of course, I know we'll get to the agency issue later, that the other side is arguing that the doctor was an agent. But yes, just strictly actions of the police. And I do appreciate the court's questions in focusing this. We know that it's an objective test for custody, but now we're talking about actions that can be arguably that would have caused or been the equivalent of interrogation under Innis. The state doesn't believe the police did anything here. I'm glad that Justice Bacon brought up the question of, well, the nurse went up and talked to the doctors. The charge nurse went up and talked to the police when they arrived at the hospital. I don't see a problem with that because, I mean, generally when the police arrive at a scene, they're going to want to talk to the reporting party. Now, granted, the doctor, whoever it was that called the police, the reporting party here is a little ambiguous. It's essentially the medical staff, the hospital. It's not like a neighbor calling the police on a loud party next door, but the police naturally are going to want to talk to the doctor, the nurse, get a little bit of information before they barge in there. I think the police acted very reasonably here. They talked to the doctor, they talked to the nurse. And I think the police are smart enough to realize that just because this charge nurse is telling them this, that, and the other, that's just for the police officer's information. The defendant didn't even know what was being told to the police. So my point being that nothing that was said to the police in the hallway would have even been known to the defendant. So going back to the
justice, that's always the
counsel. My concern here is, and I'm curious, why did the police feel like they needed to go in the room with the doctor while she's talked about the defendant's treatment? Because the doctor told the police before she went in the room, I need to go tell her about what her condition is and what we need to do next. And then she says, will you come with me? Which I find a little strange, but why did they feel like it was appropriate for them to go in the room with the doctor to discuss treatment?
Well, I would say that at that point, they clearly had reasonable suspicion, probably more than that, given that The medical staff was, and I'm doing my best to answer your question. The medical staff clearly knew that the only person that had been in the bathroom during that entire relevant time was the defendant. This was not going to be a whodunit. So you're right. The doctor does say to the police officers, look, I need to tell her what's going on. I got her accepted to Loveless and Roswell. I need to tell her what's going on. She's bleeding. I need to make sure she's stable. The doctor simply says, does one of you want to go in there with me?
No, that's not what he said. She says, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot. And she immediately asked the officer, quote, if one of them is willing to be part of the conversation, and invited the officers into the hospital room, and they both agreed. So that's, I want to be clear on what the facts are. And she says, I want you to be part of the conversation, and they both agreed. Secondly, and maybe this is another way of asking the question that Justice Vargas asked, is there any medical reason for the officers being in the room when she's confronted? Is there any medical reason for inviting the officers into the room?
I would say I don't know that there was a medical reason for them to be in the room, but
is there any police reason? Is she a threat? Is she getting up and running away? Is she doing any of those things? Is there a suspicion she has a weapon or anything? Is there any police reason for them being in the room?
And to try to answer your question, Justice Beal, I appreciate it. I've watched the video about 10 times. My memory of the video is I don't remember the doctor saying, do you want to be part of the conversation? I remember her saying something like, does one of you want to go in there with me?
But assume for purposes of this, that that's what happened.
The answer, I do believe they had a legal reason to be in there. They were conducting an investigation.
Investigation of her medical condition?
Well, investigation of what led to the baby being put in the trash.
I think the doctor wanted an officer in there because they just found a dead baby in the bathroom garbage. I mean, that's the bottom line. She wasn't under any real care. They were taking care of getting her to Loveless, to to Roswell to get her. They wanted to check to make sure because they couldn't do the testing there to make sure she was safe. She wasn't bleeding, but I think they were there. That she wanted them in there because the doctor and the staff all believe, and I agree with them anyway, that a crime was potentially committed and she put a baby in the trash. I mean, you don't put a baby in the trash. So it's as simple as that, for me anyway.
I don't remember the doctor saying, do you want to be part of the conversation? I remember her saying something like, does one of you want to go in there with me?
But assume for purposes of this, that that's what happened.
The answer, I do believe they had a legal reason to be in there. They were conducting an investigation.
Investigation of her medical condition?
Well, investigation of what led to the baby being put in the trash.
No, she says.
But if they're investigating,
she says.
we got Miranda.
Well, Miranda requires custody and interrogation, which I'll get to in a minute. But my point is that there's no legal bar to the police going into the exam room. Now, granted, I admit it. And the doctor said, "Look, I need to talk to her. I don't want you in there yet. Can you hold on while I talk to her?" I think the police, you can tell from the video, they were very deferential to the doctor. One thing I wanted to point out, because I believe now is a really good time to say that. There's a lot in the answer brief that suggests that the police presence there caused a delay or hindered treatment of some kind, or even delayed possibly her being flown to Roswell. I want to be very clear. There is absolutely zero evidence in the record that would support any fact finder in finding that any medical procedure or care was hindered or delayed, or that they even had anything to do with the helicopter arriving. So what I would say is the best answer I have is I don't believe there was a medical reason for the police to be in there, but clearly the doctor did not say, I want to talk to her in private. I don't want you in there yet. I know we called the police, we called you, but please don't go in there yet. I need to talk to her. Do they have a legal reason to be in there? Yes. Now, might it have been
What's the legal reason?
Well, they're investigating this, and they probably want to, at some point.
Watching her get a pelvic exam, is that investigation?
They were going to tell her that they found a baby in the trash, okay, and that they wanted to take her to another hospital, fly her out there. That was what she was being told in front of the officers. The officers did not question her either. They were just present. The only thing they did was take her ID and then tell her that she was not free to leave.
Well, later on in the video, when there is a point in the video when the nurse says, will you two please step out? And the police do, they step out of the hallway because there was probably some, medical,
Was that hindering their investigation, asking them to leave?
no, it wasn't hindering at all. And the police were very polite. They went out in the hallway. Another thing I wanted to mention too, and again, I think some of this is more clear when you sort of watch the video from beginning to end. There's a point in the video, pretty much exactly at 3 o'clock, where you see the police are out in the hallway and they say to the nurse, they say, well, we don't really want to go in there and cause her more stress. She's dealing with a lot. And at that point, it's 3 o'clock, you see the sergeant and the other officer go back into the room when they've clearly been out in the hallway. And the sergeant says, look, we're going to continue waiting out in the hallway. We don't want to add to your stress. We know this is stressful. And the sergeant even explains, we can't have your mom in here right now. We're waiting for the detective. You are 19 years old, but we're going to keep waiting in the hallway. We don't want to add to your stress. I know at answer brief, page 9, it certainly seemed to be making the claim that the police were in their room the entire time for that 2 hours or 2.5 hours. And that's just not true. From 3 o'clock until she was taken away by the helicopter at 4:30, pretty much 99% of that time from 3 a.m. to 4:30, they were waiting out in the hallway. And I don't know if I answered your question, but
But that was after the incriminating statements were made that were suppressed.
well, yes, but the one thing I hadn't gotten a chance to get to yet was that it's 3 minutes. It's 3 minutes into the lapel video that they tell her you're detained. You're not under arrest, but you are being detained. Put aside, of course, the cases that talk about being detained is different than being in custody for Miranda. Even if this court believed that she was in custody at that point, 3 minutes into the lapel video, and everything else was suppressed, she had already made the statements. And that's why I mentioned in the brief in chief that the motion was a little bit broad and not that the other side's motion was a little broad and not limiting the request to exclude statements to at least the point where she was told, you're not under arrest, but you are detained and you're not free to leave. But it was a little bit overbroad. And the case here, I'm trying to find the case really quick. Yes, State v. Philemon v. 2018 NMSC 11 talks about the difference between investigative detention and a custodial one, is that the latter, meaning custody, involves coercive conditions as to constitute the functional equivalent of an arrest. The one thing I also wanted to notice, and I know I'm not trying to get away from the interrogation, I'll be glad to answer any other questions on that. But of course, we know that there has to be both interrogation and custody. Putting aside the agency issue, Santiago case, whether the doctor acted as an agent of the police, there's clearly no custody here. And the cases that support that are 3 cases, well, one in New Mexico and 2 others. State v. La Couture, 2009, NMCA 71. And that's the case that was provided in the Notice of Supplemental Authority back in March. And La Couture, some of the things they say in that case are almost 100% applicable here. What La Couture said was, La Couture, and he had been involved in like a DUI or some kind of accident. He was in the hospital for injuries. And what the court said was, the fact that La Couture, this is paragraph 18 of La Couture. The fact that La Couture was restrained by injuries and medical accoutrements warrants little consideration. This is a Judge Kennedy Court of Appeals opinion. La Couture was exposed only to circumstantial restraints, and as stated above, the record indicates no action by Officer Diaz to restrain him. And La Couture, just to be clear, is not an outlier whatsoever. In the reply brief, I cited State v. Garrison, a July 2024 Connecticut Supreme Court case. And
So is it your argument today that the custody was circumstantial custody? Because it's not like, she's just delivered a baby, is bleeding out. It's not as though she's going to flee at that point. So are you asserting that there was no custody at all, or is it circumstantial custody from your perspective?
Well, custody, of course, can be formal arrest or, as the cases talk about, a restraint on liberty that basically, what's this, how they phrase it? Yes, when the person's freedom of movement has been restrained to a degree associated with a formal arrest.
So that was a follow-up question just Bacon I had, which is, so is the restraint of movement of the defendant based on the condition or that there were officers in the room? Does it matter?
But yes, I don't believe it does matter because Garrison and there's also this Johnson case that I cited in the notice of supplemental authority 2 weeks ago talk about the fact that if you're in a hospital, yes, officers may be present, but if the officers are not doing anything additional to limit your freedom of movement and they're being polite, they're not being antagonistic, that alone is not enough for custody. And in Garrison, it talks about an example in Garrison at page 289, it's 323 8th 289. The court says, because there is nothing in the record to suggest that any of the officers with whom the defendant interacted were threatening or aggressive, we conclude that the tone and tenor of the questioning weigh against the conclusion that the defendant was restrained. And I can't find it off the top of my head. The court talks in there about the fact that the real key is whether the police did anything to further restrain the movement. And probably the case that really best addresses that is the Johnson v. Commonwealth of Virginia. This is again 2 weeks ago, notice of supplemental authority, 916 Southeast 2nd 910. And what the court says in that case at page 921, so this is 916 Southeast 2nd at 921, the court says, the medical equipment connected to Johnson would have made it difficult for him to get out of bed, but his immobility was not caused by the police. Johnson was receiving essential medical care because he had shot himself in the chest.
I follow all of that, but here the police didn't like leave. They stood outside the door. They said, we're standing outside the door. They shut the door. Isn't that some evidence of restraint or custody where they didn't have to, handcuff her because she's medically unstable? But isn't the fact of their presence and standing outside the door to prevent somebody from coming and going, and they're monitoring exactly where she's going, they know she's going to be transported, all of that, isn't that some indicia of further restraint based on the language you just read to me?
I don't believe that would meet the test of state being that was cited in the brief, which is the degree associated with a formal arrest. Because again, when you look at Locketeur, Johnson, and Garrison, they really are saying that yes, you may have an IV line, maybe you're injured, you may not practically be able to leave the hospital, but the police aren't doing anything to further restrain you. So I don't believe them waiting out in the hallway would be custody, but certainly any such finding would have to be limited at least to the point about 3 minutes into the appellate video when they say you are being detained, you're not under arrest, but you're detained, you're not free to leave. But unfortunately, the trial court's ruling suppressed even the statements she made earlier when the police literally were just standing there not saying a word and the doctor was talking to her. I know that gets into the agency issue.
Well, it also gets into the privilege issue, and your time is limited here. Setting aside Fourth Amendment for purposes of our conversation and the privilege, it appears that the state is taking a position that everything that the victim said is admissible because of the doctor's requirement under statute to report that as a crime. And I'm struggling with that. I can see the doctor, as she did, say we have a deceased individual and I need to report that. But the rest of it seems at that point, you're just opening it up and all the privileges are just waived and whatever that defendant talked about is admissible. Can you address the privilege issue?
Yes, I'll do it very quickly and I'll be glad to do it more on rebuttal. Two things, 11504D4 does have the exception, and as I noted in the brief, this court clearly has, as the issuer of that rule has, and I mentioned this in the brief, has a common law ability to interpret that rule. I would say 11504D4 certainly covers this, but the other big issue is the waiver. The fact that she spoke to the doctor with the police present and her mom present.
Okay, so mom's there to take care of her?
Well, she was 19 years old though.
Okay. And the officers, to Justice Bacon's question, and you can address this, I'll give you some time. They were at least guarding, at least if we're not going into the Fourth Amendment, they were in there. So that's a struggle with that waiver.
And she's on a myriad of drugs.
And I understand so real quick, the only thing I would say, Your Honor, if you allow me 10 seconds is that
It's okay, it's okay.
imagine if the situation had been the doctor had gone in before the police got there. Let's say the police were on their way and the doctor goes in and says, well, I'm sorry to tell you, but we discovered a dead baby in the bathroom. And then she says, I'm sorry, it came out of me and I didn't know what to do. I think that would not have been privileged. And let's say the police arrive 3 minutes later, because that goes to the heart of the D4 11504 D4 exception. So I think one way to look at it is, had she made that statement in response to the doctor's statement, we found a dead baby in the bathroom, even had the police not been there, I believe that would have not been privileged under the spirit of State v. Strouts and 11504 D4. And I'll sit down and wait.
No, don't.
Take your time.
Justice Moore asked a question. Justice Moore, did you have a question?
I was more clarifying that you talked about the mom being present during the conversation and the statements made by defendant. And yes, the defendant was 19, but I might be remembering wrong. It's entirely possible. I want to see if I am. Wasn't there something she signed authorizing her mom as a caretaker or a party that she wanted?
Contact?
Maybe something where she wanted her to be present during the medical treatment. And does that do anything with the waiver issue? If my question makes sense.
I don't know if I can answer that off the top of my head without going back and looking at the record, but I believe that the general rule is that the presence of a third party not strictly necessary, like a paralegal being there during an attorney client conversation causes it to be waived. Thank you for the answer.
Thank you, Mr. Thomas. All right. 30 minutes for appellee.
So that was the state's 30-minute, well, their argument, oral argument. And then he's gonna have a rebuttal. And now we're gonna get to hear from Alexee Trevizo's attorney team.
May enter your appearance and proceed.
Thank you, Chief Justice. My name is Amber Fairberg on behalf of the defendant. Good morning, Chief Justice, justices of the court, counsel. As I said, my name is Amber Fairberg. I represent Alexee Trevizo, the defendant appellee. The legal issues here, although that conversation got somewhat convoluted, are actually relatively straightforward. It's the ramifications of this case that are extraordinary for Ms. Trevizo and for every vulnerable patient in New Mexico, and for the state's commitment to safe, confidential reproductive health care. And even more importantly, to maintaining the line that separates medical care from police investigations. Physicians and medical personnel take on the role of caregiver. Police take on the role of investigator. If we accept the state's position in this case, that line completely disappears. And it's to the detriment of New Mexico patients at their most vulnerable moment. Police are in the emergency department every single day. This is something real live doctors have to navigate every single day. And the people who are there are inherently at their most vulnerable moment. There are guidelines here. The state's position is essentially there is no limit. If there is a reason to report, and I want to get into later which reporting statute is actually applicable here. I would argue it's a suspicious death and not child abuse. Those are two separate reporting statutes. But the state is arguing if there's a duty to report, there is no privilege, there is no Miranda rights, there are no more rights. We just go on in this joint investigation.
I'm not sure that I agree that that's where the state's gone. You're blending the two. I think Miranda, the argument as I understand it from the state, isn't related to the duty to report. I think the duty to report becomes important in the privilege conversation that I really do want to explore with you today. But Miranda just seems to be, they were invited into the room and they didn't do anything. They were polite, they were nice. I heard that a lot. And therefore, there was no detention, no interrogation.
Yeah, thank you for the question, Justice Bacon. And you're right. You're absolutely right. There is the mandatory reporting falls under the privilege issue, where I think the state is largely mistaken. But let's talk about Miranda for a minute. Let's talk about that custody, because all of the cases that we just heard counsel cite are completely distinguishable here.
So when the state agrees that there was no medical reason for having the police officers in the room, does that bear on Miranda?
Absolutely.
Tell me how.
Absolutely. Well, to answer your question, Justice V. Hill, there are basically two universes we can be in. We can be in an investigatory universe where Miranda applies, or we can be in, we're here to support the doctor, and we're in the medical universe and privilege applies. The state can't thread the needle through those two by admitting that there is no medical purpose for the police to be in the room. That's effectively an admission that they're there to investigate a potential crime.
But is investigation the same as interrogation and detention?
That question doesn't go to custody. I am interested in that. I mean, does the answer, Senior Justice's question, mean they're in custody? Because then you get to interrogation.
Well, I want to make sure I understand your questions. So I want to make sure I understand your questions appropriately before I answer. There is a difference between investigation and custody, but in this case, there wasn't. In this case, there wasn't. And the reason is because of that pre-confrontation conversation that occurred in the hallway that the justices were discussing earlier. And that's that conversation where police are told by the charge nurse that she entered the bathroom to, and again, the charge nurse never treated Alexee.
That really seems related to interrogation. We're talking about custody. The question is, was she restrained? Was she free to leave? Those are the kinds of things we're looking at when we're deciding whether she's in custody. And what I'd really like to hear your take on the two cases where custody is an issue in New Mexico, and we're dealing with medical care emergency rooms, and that's Ibarra and La Couture. Ibarra, we have a defendant who is clearly in custody. He's been arrested already, and he's taken for medical treatment in the emergency room. And then we have La Couture, where they're not in custody yet. Tell me how those cases bear on this situation.
Absolutely. Ibarra says, and I don't have the pin site on me, but Ibarra says, I do have it. Ibarra uses the term an inherently coercive environment to describe the emergency department. And that's directly contrary to what the Court of Appeals said in La Couture, which effectively said this is just a normal situation, but that was factually distinguishable.
But Ibarra was already in custody. There was
Correct.
no question about custody in Ibarra.
Correct. Your Honor is absolutely right. The reason it matters, though, is because that inherent coercion also goes to custody under Munoz. Munoz gives us, the conversation earlier with counsel got really focused on custody only being a restriction of freedom to the degree normally associated with formal arrests. But in New Mexico, it's disjunctive. We have two ways that somebody can be in custody. There's that way, which normally comes with handcuffs and everything else. And then there's the second, which is that a reasonable person in the same situation, and in this moment, let's put ourselves in the mind of a reasonable 19-year-old high schooler, would not feel free to leave. And that's where Ibarra, I think, is so important, Your Honor, because it talks about the inherently coercive environment of the emergency department and cautioned police against exploiting it.
I ask you just in answering that, can you, because the state did, can you, in discussing custody, talk about the 2 minutes prior to the officer telling her that she was detained versus what happened after? Because the state seems to be breaking it up like that. And you might not agree. I'm just wondering if you can address that. Because in my mind, that could possibly be an issue. The 3 minutes prior to them telling her she was detained.
Correct. Yeah. So the questioning started 3 minutes prior to them confirming that she was detained. To my mind, Your Honor, the reason that doesn't bear on this case in the way that the state wants it to is because that was a confirmation sheet. And he said earlier, we heard counsel say, this isn't a whodunit. This isn't who had the baby in the bathroom. So there's nothing that was stated there that would have taken police from a place. And that's where that pre-confrontation comes in with the nurse, where he says, she went in there to harm her pregnancy. She's lied the whole time she's here. She's gonna lie to you, and she killed the kid. So they're operating under, we're in a homicide investigation now. She's our only suspect.
And I think the through line of what you're saying is Miranda doesn't require confirmation by the police that you're being detained. I mean, our case law all over the place handles cases where there is no confirmation.
Absolutely. And the one thing that we haven't yet addressed, Justice Bacon, is the main difference between those cases on which the state relies and this one is the placement of police. where they're either just in the emergency department, they happen to overhear, or they're standing back, and there's this independent conversation. What we have not seen in any of those cases that makes this one markedly different is that these officers were physically blocking the door. We heard counsel talk a lot about that video. In that video, we see Alexee Trevizo on the bed, hemorrhaging in a hospital gown. Those are the circumstantial ideas, right, that we talked about earlier, that your honors talked about earlier, in terms of circumstantial custody, that she's not free to leave.
So she was going to just get up out of that bed as she's hemorrhaging, okay? And she is being told she needs to go to another hospital to get checked, and just bust up and say, I'm going to leave, and the officers aren't going to let her out. That's what they're basically saying, is that she's being held and she wasn't free to leave. But she really wasn't medically cleared either. So, yeah.
It's not what puts her in custody for Miranda purposes. I mean, that's part of the coercive environment that they're exploiting, that they're taking advantage of here. But the reason she's in custody is because she has 4 authority figures acting in concert, only one of whom she's ever seen before. That's the doctor, the charge nurse. And as if you've all seen the video, he's a large man who aligned himself very strongly with police. These 3 men walk into the room and they're physically blocking the door. The operative question for the court is, would a reasonable 19-year-old high school girl in that situation feel free to leave? And the answer is no, even if she wasn't hemorrhaging, even if she wasn't hooked up to an IV, even if she hadn't just experienced the first vaginal exam of her entire life and the precipitous labor and delivery of what the defense posits was a stillborn in the bathroom.
How do we know that this was her first vaginal exam? She's 19 years old. So she's never had a pap smear before at 19. She sure had sex before, obviously. And she was so fearful to leave. See, I don't think that at all. I don't agree with that.
Contextualize it, yes, Your Honor.
I don't mean to interrupt you, but I really do want to talk about the privilege. We have not had an opportunity with the state to really talk about the privilege either, but I need you to identify something pretty specific to me, because I don't know the answer to the question.
Absolutely.
What, to your client's mind, did the doctor say? What's the actual violation of the privilege? What are the words spoken by the doctor that you assert are a violation of the privilege?
I'm not sure that that's the way, Your Honor, that I conceptualize the privilege. The privilege is a rule created by this court as a rule of evidence. So the question is, so the doctor can invoke Alexee's privilege for her, and should have, but did not. And should have a pursuant to medical ethics and her professional guidelines, and did not. But in terms of waiving the privilege, only Alexee can do that. And so this is a
Before we waive, get to, it's a privilege.
Yeah, I mean, why is this? What is the privilege being asserted here? I mean, I know that it's a physician patient, but what is happening? What have you identified as triggering the violation of the privilege?
Well, the violation, there's actually 2 different violations.
Okay, and that's what I want to try and
Yeah,
understand.
there's, and you can see this from the court order, because we've got the district court made an order, one on the statements made directly responsive to the collective confrontation in the room, and also.
But that's what I want to try and get to, because if the privilege you're asserting that's been broken is the statement of, we found a baby in the trash, that's not a privileged statement, because it's not about Ms. Trevizo's healthcare. It's just a statement.
I'm not sure I would agree with Your Honor.
Well, let me
Okay.
finish. So to me, that is not a violation of privilege. The remainder, we need to transport, bleeding out all of that information, I might agree with you as a violation of the privilege, but in this context, given the suppression here, I don't think anybody cares, because that comes after the inculpatory statements by Ms. Trevizo. And so if that's a violation of the privilege, sure, but it's not what is really at issue here.
What's really at issue here, Your Honor, are Alexee Trevizo's statements. It's not the doctor making a statement. The doctor and the nurse both did violate their duty of confidentiality several times by telling officers, I think you said earlier, Justice Bacon, I'm not sure they should have, but to get to the actual statement that is, there's two realms, but the one that is responsive is Alexee's statement. Alexee's statement, which was made for the purposes of treatment and diagnosis. That's the standard under Rule 504. And the reason here that it is, the doctor comes in and says, I'm sorry, there's police here. We found a dead baby in the bathroom. So this is the first time the doctor has spoken to Alexee, and she made it clear later in an interview, and her actions made it clear at the time. And this is the substantial evidence that the district court relied on, that she wasn't going to get treatment without police present. So this information, the doctor didn't know where the placenta was. Indeed, the placenta was never found. The doctor didn't know anything about the circumstances of the birth. So Alexee's statement confirming that birth is absolutely necessary for her ongoing diagnosis and treatment. The problem here is not, I think where we're a little bit stuck is we're imagining that the police could have come in and maybe the doctor could have said something different that wouldn't have triggered the physician-patient privilege. And I would say, no, the police should absolutely not have been in the patient care room, nor should Dr. Vasquez have instructed her entire ED staff not to interact with Ms. Trevizo except for in the presence of law enforcement. She effectively conditioned her ongoing treatment on their presence.
So why, talk to me then about waiver.
So all she's talking about is Alexee's rights and how they broke her rights and her confidentiality. But what about the rights of the baby? What about the hospital's ability to care for a baby that was born inside of a bathroom inside of the hospital? And they wanted to be concerned about that as well as the mother, aka Alexee. So she just wants to drop off the fact that they were concerned about this child as well as Alexee.
Okay, let's talk about waiver. Yeah. So here the state is effectively saying, and this is how I understand it, that Alexee has waived her privilege by the presence of third parties. Well, all we need to do is look at the text of the rule. The rule, and instead of me paraphrasing it, I'll just read it because I think that would be probably better. The rule defines confidential communications, and then we can get to the exception, which is the mandatory reporting exception. But the rule defines confidential communication as a communication made privately, not intended for further disclosure, and then this is the operative language, except to other persons in furtherance of the purpose of the communication. Now that has a little bit of a loop-de-loop feel, because what does it mean in furtherance of the purpose of the communication? We know that from the first part of the rule, which says that the communications that are privileged are those in furtherance of diagnosis and treatment. We also have direct case law on point that says, we look at State versus Roper, and granted, Roper was construing an earlier version of this rule that specifically said family members were exempted from the privilege, from waiver. But the current version of the rule actually broadens it. And it broadens it so that it reflects the reality of New Mexico, which is that no person is going to the emergency department by themselves. Every person has a support person, whether it's extended family, whether it's their mother. I mean, and this idea that she's 19 and therefore it doesn't matter, that's not reflected in the law. The law says that any person, it's not someone who's absolutely necessary for care. It's someone who's there in furtherance of that care.
But so the officers are in the room and
Officers
they are not in furtherance of her care.
I would argue, Your Honor.
Would that be a waiver? I mean, I think the state asserts that that's a waiver, like that she's cognizant of what's happening and makes a knowing decision. I don't care that they're here. I'm going to answer this question. It's not a question, this statement for purposes of furtherance of my care.
Right. I think in that idea, it kind of loops back on there's two things here. One, it loops back on the idea of Miranda, that a statement, any waiver needs to be voluntary. And so for the same reasons we would argue she didn't voluntarily waive any rights under Miranda. She didn't voluntarily waive any rights.
So, Ms. Faber, assuming for purposes of discussion, assuming that the statement by the doctor, we found a dead baby in the bathroom, was a violation of the physician-patient privilege in the context of everything that's going on, she never had a chance to waive.
Correct. Right.
There's no waiver.
Right. You can't waive a right that you've not been informed of.
And she had no, and by the way, a fact I think that you left out, and I don't think you meant to, on the custody, is that the officers were armed,
Absolutely.
visibly armed.
Absolutely, visibly armed. And if I could just add one more thing to speak to that, Justice Vigil, and also finish answering your question, Justice Bacon, they also fit into other persons because the reason is because of what the doctor said. That and the charge nurse verified it and said the exact same thing. No one's talking to Alexee, AKA no one's treating her except in the presence of police. So in that situation, they're absolutely in furtherance of care because she's not.
But how is the mom in furtherance of the care? She's actually she was questioning her daughter more than the police were. And it wasn't about her treatment. It was about, you did this and you're going to be in trouble and all of those comments. And in fact, if I remember correctly, I think the police even at one point said, please stop. So how is the mom there in furtherance of her care?
I think we have to step back and look at the totality of the circumstances for that. The statements that you're pointing to, Justice Zamora, or from mom are her own reactive statements to what she's just learned. But in the course of Alexee's care, she brought her there as her emergency contact. She was asked by medical professionals at one point to help her get into her gown. She's been going back and forth to the bathroom to knock and see if she's okay. She's sitting by her daughter's side. She's advocating her. That's absolutely in furtherance of care. Just because we now in retrospect think, oh, some of her statements might have been against Alexee's interests, that does not mean that in the moment she was not there in furtherance of care and that the physician-patient privilege does not attach.
So we have exceptions to that.
Correct.
Let's talk about those.
Let's talk about D4.
Let's talk about a statute that also exempts it, a statute by the legislature. We have, interestingly enough, this privilege exists in statute, seems a fair rule, was generated out of common law, 32A45. And let's talk about those two things because it seems to be a high burden on this doctor who has an obligation to report a crime. I think perhaps lawyers have that obligation. Take a separate factual scenario in which they ask a 25-year-old, stabbed in the leg, I killed somebody. They having that conversation as a doctor and a patient, I'm not sure it means the exception doesn't apply. Why doesn't the exception apply?
So you're saying, why doesn't the mandatory reporting exception apply to the statements that are happening after the collective enters the room?
Or under the statute shall not be excluded on the grounds that the matters be subject of a physician-patient privilege or of their similar privilege under 32A or 5.
Right. So I think there's a couple of things here. And one of them is that the report was already made to the extent that it was applicable. And I just want to step back for a moment because we've got two operating statutes. The state has focused exclusively on 32A43, but there is also, for your honors, 2411.5, and that's reporting a suspicious death. 32A43, is part of the Children's Code, and we know from Strouch and its legislative history that the purpose of that statute is to intervene and protect a child from ongoing abuse. And so hence the mandatory reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen, including you have to report it either to police or to CYFD. If it goes to police need to report it to CYFD. CYFD then gets involved. That's not what's happening here. There's nothing in discovery. There's nothing in the record that police ever got CYFD involved because this isn't the operable statute. The operable statute is instead 2411.5, which is reporting a suspicious death. There is no dispute here that doctors did not try to resuscitate this neonate, that they found the neonate cold, blue, very clearly deceased.
I don't disagree with that recitation, but there also is an OMI report, at least according to the briefing. Is this a question of fact?
I think that part probably is a question of fact, but what's not a question of fact, yes, the stillbirth versus live birth is absolutely a question of fact. But the issue of what people knew at the time, as far as a report, there was no OMI report at that time.
It does triggering the suspicious death statute.
Correct. All they saw was a suspicious death. And so that requires one of two things, either a report to local law enforcement or OMI. And then it's up to those people to take on the investigation. But even if we are operating in the realm of 32, of the Children's Code 32A43 and 32A45, I would still argue, Your Honor, that any reporting is not prospective reporting. It's not an ongoing duty of some sort of ongoing duty of disclosure. That would de facto turn a doctor and any other mandatory reporter into an investigator by police.
The only thing the doctor was required to report was we found a dead baby.
I would say that the doctor was required to report the basis of her reasonable suspicion for child abuse. So we found, that's what the statute says. And that's what happened. We don't know that the doctor did it. We think it was and obviously the nurse was the first one to have a conversation with the police. The report was made. Now it's up to them to take on their investigatory tools. It doesn't mean they have an ongoing open entry into her medical records. The other thing that I would point out for Your Honor, especially Chief Justice, I want to make sure I'm answering your question, is that the records referred to in the Children's Code, I would argue generally referring to the records of the abused child. It doesn't mean, well, now let's look at the suspect and prospectively and in an ongoing manner have access to their records. That's why we have other investigative tools. They could have gotten a search warrant for her DNA. They could have gotten they could have taken her clothes and conducted communications on those. They could have gotten other warrants for medical records. They could have subpoenaed things. They didn't do any of that. Instead, that very night between them and the hospital.
Some of it is based, some of the duty to report child abuse is based on the mother's records, because the pregnant woman who her toxicology screen might report a basis for child abuse, her self-report or clinical observation. I think when it's a drug exposed baby. So there's some basis in the statute. We're not just looking at the child.
Correct, Justice Zamora. But what that portion of the statute also shows us is New Mexico's commitment to reproductive health care. And that what that section says is that mom's status as having used drugs is not an automatic showing of child abuse. So I think here, if we're reading it in total, but I still would urge Your Honors, I think that the morass of 32A43 is avoided entirely by realizing what doctors saw, what they perceived, what mandatory reporters perceived was a suspicious death. We're not in the realm of CYFD. That's just not where we are here.
We're in the realm of doctor-patient privilege.
Correct.
If the defendant would have said instead, same scene, and the defendant would have said, the doctor says we found a deceased individual in trash can. And the defendant said, I killed that individual. Would that have been privileged?
Well, Your Honor, I would say under that hypothetical, no, the reason being that statement would not be for the purposes of diagnosis and treatment.
Okay.
Yeah.
Fair enough. So let's get to the statements that are suppressed and tell us how that falls. Basically, in essence, the defendant said, the baby fell out of me. That, your view, is tied to direct medical treatment because of the hemorrhaging. Understand that?
Not only the hemorrhaging, but what she's describing, what Alexee is describing, what we hear from hospital personnel and what we hear from the state is that from the moment Ms. Trevizo got to the hospital, that she was lying. Well, what do they base that on? That she said that she was bleeding, that she was in 10 out of 10 pain, and she wasn't pregnant. It is surprisingly common how many people don't know they're pregnant until well into that case. So that's what they're basing her lying on. But what it really shows, and
But they delivered at 10.
not only that, Justice, but also it shows an obstetric emergency. She was probably having a placental abruption. And so what her describing to the doctor what happened in the bathroom would have been extraordinarily important. It is extremely unusual for a woman to be able to go into a space and within an 18-minute period deliver a baby, deliver a placenta, and then walk unassisted back to her room. That demonstrates the amount of morphine that she probably had in her system at that point, because I think, just as a matter of common sense, that's not something you should really be able to do. She would have been, so the idea here is she was in the midst and continued because of the hemorrhaging in the midst of a placental abruption. The doctor did not know where the placenta was. Had any of that been retained in her uterus, she would have bled out and died. So the idea here that her job, she had nothing for medical purposes to say to the doctor is simply not the medical reality. They needed to have an open conversation to make sure she got the care that she needed.
Can I ask a really different question that's just been?
If she didn't come in there and lie that because she said, I'm not pregnant, and they asked her multiple times, no, I just have a backache. And she refused to get undressed for quite some time. So she delayed her own care. And she put not only her baby at risk, which sadly is gone either way, but she put herself at risk because she wasn't honest with the care team.
Can I ask a really different question that's just been weighing on me? So assume the court agrees with you on either Miranda or privilege. Case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here? And so I see, like, you all will be gone. There will be a new attorney involved, probably a public defender, and we will have excluded statements that are consistent with what her defense is. And that just troubles me in a weird way. That's why I said it's just a related but far field question.
Yeah, I think that I appreciate the question, Your Honor, and I'm not going anywhere. I'll be there for trial to the extent that it happens. But that's just not the operative question for the court to think about trial strategy and so on. I would point the court to State versus Gutierrez, in which this court has decided that they take a different approach than the feds do, for example, on constitutional rights.
Most things.
On most things. And that approach is, we vindicate her rights because they need to be vindicated, not for deterrence, not for anything else. Her rights were violated. What we need to do here today is try to right that wrong. And then when we get to trial,
she decides to voluntarily use the information.
Correct.
No harm, no foul.
Correct. Okay. Exactly, Your Honor.
Thank you.
I realize that I am running with only 38 seconds left to go. And so I just want to highlight for the court, and I want to make sure I answer all of your questions, but I want to highlight for the court the policy impact for New Mexico of this decision, that it really matters. The stakes here just reach far beyond Alexee. If the state's position is adopted, the message is clear. And that's, in moments of crisis, patients can't trust what they say to medical staff will remain confidential. And that's going to chill patients, especially adolescents, especially our rural patients, especially our vulnerable patients. It will also destabilize the physician-patient relationship that forms the bedrock of our healthcare system. And the district court drew that line correctly. Miranda and Rule 504, the relevant medical ethics, mandatory reporting statutes being narrow, that's where the line lies. In this case, it was completely obliterated. So to erase those safeguards would not only reweigh the facts, we haven't talked about standard of review here, but would not only reweigh the facts, which is what the state's in court in encouraging this court to do, but it would also reshape emergency care so that vulnerable patients would be at risk. And I just want to end on one thought, Your Honors, and that's that this case isn't about whether hospitals can notify police of a suspected crime. They can. And in most cases, they must. It's about what happens after. It's about what happens after that notification. Doctors are caregivers. Police are the investigators. Our law keeps those roles distinct. And it's essential for New Mexico that we continue to keep those roles distinct. And I just want to thank Your Honors for your questions and also ask that you please affirm the district court's order on both grounds, privilege and Miranda. Thank you.
Okay, one moment. Let's see if we have any other questions. Okay, thank you, counsel.
Thank you.
All right, Mr. Thomas.
Thank you.
10 minutes.
Thank you. Yeah, I just wanted to start off, Your Honor. I will try to talk slower.
It's a lot. It's a lot. I think as you have this conversation, if you can help us separate the Fourth Amendment part and the privilege, but go ahead.
Yeah, and I did make some notes, and please jump in with questions, but I did make some notes about just a few things I wanted to really hit quick. One is that I don't think there's any issue here about whether the doctor had a duty to report, because whether you call it under 32A43, and I did realize that 32A43 talks about a neglected or abused child, but as I pointed in the brief, just from this court's common law interpretation, and it would be odd to say, well, you have a duty to report an abused or neglected child, but not a dead baby. And I'm not going to read much. I don't want to get into the details much, but the defense's own Exhibit D at the suppression hearing, the defense's own Exhibit D, as in Delta, talks about how the Leela, the custodian lady, what caused them to call the police was that she had found a baby wrapped in a trash bag under another trash bag. Now, as sad as that is, clearly that's a suspicious death. No different than if a 30-year-old had been found in the cleaning supply room with gunshots to the head. And so I wanted to make a few other quick points. So in custody, I know there was a lot of talk about what the charge nurse said, and I maybe didn't articulate this really well earlier, but my point was that whatever was told by the charge nurse to the police would not have affected the defendant's objective, reasonable view. It's an objective view of what a reasonable person in that situation find themselves to be in custody. And none of what was said to the police in the hallway would have been known to her. It's worth just a few.
But it's not about what was known to her. It's about what was known to the police when they said, yes, sure, we will go into the room and have the conversation with you, because that's their yes to the statement. So it's not about what she knows. It's about what the police know and what their motivation was to go in the room and have a conversation with Ms. Trevizo.
And I understand that, but and certainly if the police had gone there, going home with their guns drawn or something, saying, you're not going anywhere, you know, and immediately have made it clear you're in custody.
But they don't have to say any of those things for it to be custody.
And I understand that, but certainly what the defendant is perceiving or hearing is really, what is the defendant perceiving and reasonably hearing and seeing? The one thing I wanted to point out is this reference to the police being armed. I mean, it's common knowledge to anybody that the police are armed. They could be safe 1 minute and 10 minutes later be dealing with a very dangerous situation. I'm not saying in any way, shape, or form the defendant.
But what about where they were standing in the room? Opposing counsel talked about their location in the room, which was in front of the door. That doesn't seem to support the position that it was not in custody.
Although I would argue that the fact that for nearly about 2.5 minutes, they said absolutely nothing. They just stood there and observed certainly bears on defendant's perception. Just a quick 1 or 2 quotes from Garrison, because Garrison really, the Connecticut case gets to the heart of this. Garrison talks about not all restrictions on a suspect's freedom of action rise to the level of custody. And then they go on to talk about whether a reasonable person would believe that there was a restraint associated with a formal arrest. But another thing that Garrison mentions, I guess this is the part I looked for earlier and I couldn't quite find earlier. Garrison says there's nothing in the record to suggest that a reasonable person in the defendant's situation would have perceived the police officers to be exercising any control or authority over the medical staff. Indeed, the record demonstrates that the officers did not assert control over the medical staff, and that the questioning did not delay, interrupt, or restrict the defendant's medical care. I don't want to belabor the point, but if you do get a chance to see in Johnson, the Virginia case from the notice 2 weeks ago, Johnson gives a list of the kind of factors that might be relevant in a hospital, and one of them is whether the police maintained a constant presence in the patient's hospital room. As I noted, from about 3 a.m. to when she leaves in the helicopter at 4:30, you can tell from their camera they're out in the hallway. But one other thing I wanted to
But
mention,
they've told her,
I understand,
We're out in the
but she had already made the statements.
And they,
which is equivalent to being in the room, to be like, we're standing out right outside the door.
Yes, but again, at the point of the 3 minutes into the lapel video, when they tell her you are detained, you're not free to leave, you're not under arrest.
You're the one who
detained.
raised they were outside the room. You want to focus on the 3 minutes, but you also want to focus on, oh, they were good guys. They left the room after the 3 minutes. Can't conflate it.
Yeah, and I understand, but my only point is that even if the court wants to consider the point where she's told she's detained to be custody, the motion should have been more specific on that, because I don't think there's anything in the first 3 minutes until she's told she's detained that would lead a reasonable person to believe they were in custody. And I would be remiss without at least mentioning this. If you look at the judge's findings at RP 159, I'm sorry, 158. The judge in her conclusion of law number 3, record proper 158, the judge says, Dr. Vasquez, by failing to advise Trevizo of her right of confidentiality, and she cites Rule 11-504, acted as an agent of law enforcement. I'm not reading the entire paragraph on RP 158, paragraph 3, but the judge seemed to be reasoning that because the doctor did not go in and affirmatively say, before you say anything, you have a physician-patient privilege, that the doctor's failure to advise the defendant of that made her an agent. There's several problems with that. That's not the test that Santiago provides. Santiago, of course, is the case. This court, 2009 NMSC 45 says, it's A, whether the government knew of and acquiesced in the conduct, but 2, whether the party performing the search intended to assist law enforcement efforts or to further his own ends. And Santiago makes it crystal clear in paragraph 24. It makes it clear that if it's a mixed motive, that's not enough. So in other words, even if the doctor was thinking, I do want to help the police, but I'm also concerned because I'm the doctor, I'm in charge of the ER, it's 2 o'clock in the morning, they're going to be Artesia General Hospital Board of Directors to answer to. I need to find out what's going on. I also need to find out how it impacts her care. Because one thing that's clear from the video is the doctor through all this made it clear your care is paramount. Even Sergeant Anaya says the number one priority is your care. We're going to step out if we need to, and the number one priority is your care. There's no evidence in the record that the doctor was motivated solely to help the police.
wait a minute. This girl goes into the emergency room. She's got these backaches. She's asked, are you pregnant? She says no. They then do a pregnancy test. It comes out positive. They don't tell her. They don't tell her that the test shows she's pregnant. After the baby is delivered in the bathroom. So she comes in and says, we found the dead baby in the bathroom. Worse to that effect. It gives weight to the assertion that they thought from the beginning, the doctor thought from the beginning, she lied when she said she wasn't pregnant. And now she's confronting her without the benefit of having given her any medical information that she in fact delivered a dead baby. So that seems to me pretty agency oriented in terms of assisting the police.
Well, again, Santiago says that it has to be solely to help the police. Santiago says that there's any kind of mixed motive, like you have a professional
An
interest.
inference can be made, it is solely to help the police.
I don't believe that inference can be made under Santiago, but I will say this, Justice, and I think this points to a good point. Even if you give the defendant the benefit of the doubt that she did not know she was pregnant, immediately upon giving birth, the natural thing you would think anybody would do is, help, I just had a baby, help, I need help. She did not tell anybody for 30 minutes. It was 30 minutes later that the cleaning lady found the baby, and obviously another 5-10 minutes till the police showed up. I think one can make a good argument that she did not even from the beginning avail herself of the physician-patient privilege. State v. Roper, 1996 NMCA 73, paragraph 6, said the privilege is designed to encourage patients to make complete disclosures of symptoms. I would argue that if you're hiding a material fact from the doctor that you just gave birth to a baby, you're not asking for help, arguably you're not even availing yourself for a privilege. Now, I understand after the fact, now that she's caught and she's in trouble, she wants to say, my privilege was violated. But State v. Strouds, 2015 NMSC 9, paragraph 44, states expressly, privileges often have limits, particularly where there are conflicting interests that may outweigh the interest of confidentiality. And it's interesting that Strouds notes in paragraphs 29 to 31 that New Mexico in 1973 became one of the earliest states in the country to impose a mandatory reporting duty on all persons. So New Mexico has a rich history of protecting children and babies. And the other one more thing I wanted to note is it's also interesting that some of this privacy and privilege is a little bit pick and choose what serves me. There was a lot of emphasis in the answer brief about privacy, and they didn't respect her privacy. And yet there's something in the answer brief where they say, well, the hospital let her go to the bathroom unattended. Well, she's 19 years old. It's ludicrous, almost incredible to me that they expected the doctor to go into the bathroom or a nurse to go into the bathroom and stand over her to make sure she didn't do anything. So there's got to be some treatment of, you're 19 years old, you're a responsible adult. I think that's been a little lacking here in terms of the defendant certainly has rights, she's on trial, but there has to be something said for the baby's rights too.
Thomas, anything else? Any other questions? All right, thank you.
Thank you, Your Honor. Thank you for the good.
So I think that the state attorney did a lot better on his rebuttal. That's a good thing. So hopefully he ended it on some information that stood in the minds of the justices. I'm glad that he spoke up for the baby's rights, and of course how he mentioned how Alexee could have asked for help while she was in that bathroom. She didn't avail herself of medical care when she quote unquote needed it, and decided to later on admit that that she gave birth in the bathroom after they discovered the deceased baby in the trash. So the next steps are going to be, we have the oral arguments which just happened. So the next steps in the case with the Supreme Court is going to be, they're going to have a conference. Sometimes the justices know how they're going to vote in the case, but not always. So they will have a discussion, a conference together, and they'll go over the oral arguments and that sort of stuff, and pretty much they're just going to discuss the whole thing and see where everybody else stands. Then they will have voting. They will do the process of the voting. Everyone votes at the same time, and the Chief Justice votes first, and then it goes on and on from there. And then opinions will go out. There's a justice who will write the opinion of the court, and they have to make sure that it properly expresses the views of all the justices who voted in the majority. So it has to be pretty clear, and then it will become official at that point, and then it will be published. The justice who wrote the opinion will summarize it from the bench during a regularly scheduled session of the court. It will then become available to the public, together with any other opinions in the case in various temporary printed forms. Ultimately, all the opinions on a case will be published officially in a case books known as the United States Reports. So there's a few more steps to go, and I don't know myself how long that takes. I mean, I'm assuming it can vary. But if you happen to know what the normal time frame is, I did do a quick Google search, and I'm not really seeing that. I don't even see it on the New Mexico Supreme Court site. So I don't know if they'll go through the rest of their oral arguments this month, and then they'll do a voting on all the cases from September. I'm not really sure how that goes. But we're going to just keep an eye on it and hope that they vote in favor of the state and leave this body cam video in. So we shall know probably in the next few weeks or so. But let me know your thoughts in the comments. And with that said, I hope you have a great rest of the day. And most of all, stay safe.